Next order.
Order number 2, communication from the chair.
Next order.
Order number 3, messages.
Next order.
Order number 4, petitions.
Next order.
Order number 5, papers.
Next order.
Order number 6, notices of motion.
Next order.
Order number 7, questions and statements.
Honorable members, pursuant to the provision of standing order number 47A, the Speaker may designate a suitable place in the County Assembly chamber for the purposes of admitting any County Executive Committee member for purposes of presentation of information, answers to the question the County Assembly contemplated under Section 39 into bracket 2 of the County Government Act 2012. It is in this regard that that County Assembly invited the County Executive Committee member for lands, physical planning, and urban development is appearing here today to answer to the question raised by Honorable Newton Kifuso, Honorable Joseph Morega, Honorable Joseph Mabishi, Honorable Jonas Solomon, Honorable Peter Shambi, Honorable Amos Mwakalo, and Honorable Anissa Wakio. Honorable members, in view of the foregoing, honorable members, I hereby direct the Sergeant at Arms to usher in the County Executive Committee member for Land, Physical Planning, and Urban Development into the chamber. Honorable members, may I take this opportunity to welcome the chairperson, the County Executive Committee member for the lands, and that one I know is and urban development into the chamber on behalf of the County Assembly. Who is the chairperson? Honorable members, I think I've ordered the Sergeant at Arms to bring in the, was it okay? Honorable members, may I take this opportunity to welcome the chairperson and the County Executive Committee member for the Lands, Physical Planning, and Urban Development to the chamber on behalf of the County Assembly. Pursuant to the standing order number 55-1, the clerk shall submit to the relevant county executive committee member for the question within 48 hours of being made in the assembly, accompanied by with summons to appear before the county assembly. The clerk of the county assembly submitted to the county executive committee member the questions scheduled for his response on Wednesday, 8th October 2025. However, the responses provided were found to be insufficient. Consequently, the chairperson directed that the county executive committee member appear before the assembly during the afternoon sitting of today, Tuesday, 4th November 2025, to provide comprehensive responses to the question. I accept as the speaker may direct, a question shall be responded to not later than the 14th day after the request is made in the county assembly. Honorable members, the following shall be observed during the appearance of this county executive committee member. Rule and order when county assembly, and I want you to listen very careful, unless specifically provided in this part, the provision of part 13, rules of debate, and part 20, order in the county assembly and committee of the whole county assembly, shall with the necessary notification apply during attendance of the county executive committee member to provide information and answers to the question in the county assembly chamber. The provision of the County Assembly's Powers and Privilege Act number 6 of 2017 shall apply to County Executive Committee member when summoned and admitted and answering question in the County Assembly chamber under the part. County Executive Committee member shall at least one day before the day of presentation of response to a question or such other period as the speaker may allow, submit 5 copies of the response to the clerk. The county executive committee member submitted to a response to the clerk of the county assembly on Monday, 3rd November 2025. The speaker shall call successfully each member in all name. A question appears in the order paper. The member called shall raise and ask the question by reading out of the text of the question, and it is printed in the order paper. A member in charge of the question may authorize another member to take charge of the question on his or her behalf. Where a member fails to raise a question at the time specified by or under these rules, such questions shall not again be published in order paper during the same section except with the leave of the speaker. A question shall stood over if the relevant county executive committee member is not present in the assembly, and when the question comes up for reply and the question is not replied to on his or her behalf by another county executive committee member, provided that the relevant county executive committee member shall have sought the leave of the speaker. A question may not be stood over more than once. The county executive committee member shall be heard silent, and no interjection, point of order, or question of privilege shall be raised while the executive member is providing information. Each county executive committee member response shall be limited to a maximum of 30 minutes, provided the speaker may in exceptional circumstances extend the period by not more than 30 minutes. Member may seek clarification on any answer given, but clarification shall be limited to the specific matter raised in the question, provided that A, any clarification shall take the form of a question and not a debate. B, the member in whose name question stands or takes a charge of a question shall be given an opportunity to ask one supplementary question. C, a member who asks a supplementary question pursuant to the subsection B may make a statement or express an opinion, but may not speak for more than 1 minute. The speaker may, if the question is certified that the response sufficient, addresses the matter specified in the request, direct the matter be closed. Where the question is not certified that the response sufficiently addresses the matter specified in the request, the speaker shall refer the reply submitted to the relevant sector committee for further consideration. Honorable members, I now invite Honorable Newton Kifuso. Of course, I think it's provided that when the question, the CCM will stand and respond as per the question from the honorable member. So may I call upon Honorable Kifuso, and also Waziri, you may make a note on that, although I know you have the questions with you. So may I invite Honorable Kifuso to read the question.
Thank you, Mr. Speaker. Mr. Speaker, in our last session, when the CEC appeared, I had asked the question, but my issue was the supportive document. So that is all today. As per my question, it was supposed to be submitted. The supporting document, of which have been handed. So that's what I wanted. So the question I had already asked, and when she was responding, I had requested that I needed the supporting of what she was responding to substantiate. So I've been provided here. I need to go through them, and in case of anything, I will come and raise it in another session as a question or a follow-up statement. Thank you, Mr. Speaker.
The CCM, now the Waziri may stand also tell us what he has provided, so that at least we may understand what has been provided in that big document.
Okay, thank you, Mr. Speaker. The supporting document that I was supposed to provide was the evidence of the single business permits that were provided for the years from the questions. So the evidences that I've provided are to add on, there are invoices that have been they have been issued to the companies that are supposed to start mining, because they have applied for prospecting mining. So I've provided the notices to comply with the business permit, and also the number of business permits that have been granted over the 2 financial years. Yeah, from the revenue departments. That one in individual grants of permits. So that's what I've provided for those companies. Thank you, Mr. Speaker, sir.
Honorable member, you can now tell us, are you satisfied?
Mr. Speaker, as at now, because of what I had requested in this house, it has been provided. I think I'll say I'm satisfied because I've been handed all the documents plus the additional companies which had asked about the archipos, the subrouters and everything. And I'm seeing all of them, they are here. So in case there'll be any issue, I'll refer to the committee and they will handle at the committee level. Thank you, Mr. Speaker.
It's so very much okay for the honorable member. And my directs that now anything that is going to be raised out of what you have provided, then let that be directed to the relevant committee in this house. Let us go to the next question. That's question number 2 and number 2. Number 2 and number 3. Honorable member, I want to invite Honorable member Joseph Mwarega to ask the question on ownership status of the land under construction, the ICT hub in Mwatate ward belonging to the St. Joseph Church, and ownership status of plot located in the Peleleza area of Mwatate. Joseph Mwarega.
Thank you, Mr. Speaker. Maybe I should read the question again because last time we went through the question, but I'll just go through the question so that Madam CECM should give the correct answer concerning the question. Ownership status of land under construction for an ICT hub in Mwatate ward, allegedly belonging to ACK St. James Church. What is the current legal status and ownership details of the aforementioned parcel of land located in Mwatate? Last time, Madam gave the response, but it wasn't sufficient. She was supposed today to come with the evidence showing the area covered by the ACK and the area covered by, which is covered by the public land where now the project is being undertaken. Thank you, Madam. Mr. Speaker, should I go through all the questions or all of them? Okay, thank you. Thank you, Mr. Speaker. Question number 3. Ownership status of plots located in the Peleleza area of Mwatate. Ownership status of plots located in the Peleleza area of Mwatate. Question number 1. Who are the officially recognized owners of the plots in Peleleza as per the county government records and the State Department of Lands? Question number 2. When were these ownership records last updated? Question number 3. Is there a verified list of individuals or entities currently paying rates for the Peleleza plots? Question number 4. How does this list compare to the actual residents and occupants on the ground? Question number 5. Has the county government or any other relevant authority undertaken any land adjudication, regularization, or titling exercise in Peleleza? 6. If so, what were the outcomes and how were beneficiaries determined? Question 7. What measures are in place to protect long-term residents from potential displacement in the interim? Thank you, Mr. Speaker.
Before I invite the CCM, let me first of all recognize members of the public gallery who have visited our bunge, led by Brenda Mwashinga Jomba. Thank you. We have also Pastor Rina Mwanake. Also we have Leonard Mwamzinyi. Also have Ngeti Rube. Okay, welcome. Honorable members, let me now take this opportunity to welcome the County Executive Committee member to respond.
Thank you, Mr. Speaker, sir. I wish to respond. The overview, I wish to note that the utmost importance of having the project within the area, as it is perfectly aligns with the spatial planning goals of having major ICT hubs at the sub-county level. The project, though is being implemented by the national government and did not have stakeholder engagement on the suitable location of its development. Based on the concern raised, I wish to report that number one, the current status of ownership details of the aforementioned parcel of land located in Mwatate. The area is generally wholly reserved for the county government land to accommodate various public purposes and utilities as per adjudication records. However, in this particular moment, we cannot ascertain the size of land which the church claims, since the process of adjudication is still ongoing, and the land is not registered. Moreover, the request we made adjudication terms to reserve the areas as part of Mwatate core urban area to cater for planning and allocation of various land existing in proposed to be in the coming future. Umarisechu has a history of dating back in 1960s when it began, how public land was being reserved, and also how the church was accommodated into the section. Therefore, based on the ascertainment of rights, we cannot claim the ownership of every empty plot of the area without the final registration of the section of allocation of space done under urban planning initiative. Also strongly advocate for all stakeholder involvement in utilization of limited space which the county owns to accommodate key prior projects which will boost the headquarters operation and service delivery. Thank you, Mr. Speaker, sir. Am I allowed to invite Assistant Director to respond more on this?
You are supposed to have the question written. You are the only one who is supposed to respond.
Okay.
Yes.
Question 2. Okay, maybe I can expand further on this relating to adjudication. The adjudication could not provide any information to us because the allegedly process is not over, so they said they cannot give us incomplete information, which may change time to time as they continue doing the adjudication and beaconing. So unless they finish up with the beneficiary lists, it's when they will be able to provide full information on the said adjudication which is going on at Chabia Research adjudication. Thank you, Mr. Speaker. On question on Peleleza, Peleleza overview. Peleleza Mwatate area was planned and plots allocated by the County Commissioner of Lands way back in 1990s. A portion comprising 24 plots, that is 18,324 to 18,345 was surveyed. Several allottees by the County Lands, Commissioner of Lands were non-residents in court. Later on, the County Council issued its allocation documents on the same area, but it was not clear what the basis of allocation was. There are cases of absentee allottees who never took physical occupation of the plot, yet they pay rates. A good number of the settlers are squatters who know ownership documents and they don't pay land rates to the county government. Number one specific question. Official sources of information on plot ownership are land registry, that is land registrar's office of land register, rate payers register held by the Department of Finance. Number two, the only non-register is on one compiled by the County Council. It is not clear when the register was updated, but the latest information of land ownership at Peleleza is provided on 15th June 2025. Due to the informal nature of land holding transaction, sale, transfer, and registration, there is no single list of ownership or verifiable register. Number four, there is need for audit and verification, that is to carry out physical verification on land ownership in the area. Number five, no adjudication, regularization, or titling of plots have been carried out at Peleleza. However, there is evidence of individual land registration having taken place. Number six, since there is no initiative has been taken, it is common practice that land ownership is determined from those that voluntarily present themselves with earlier lease documents, allotment letter, both by Commissioner of Lands and de facto County Council, and major sale agreements and such other documents. Number seven, to protect landowners in Peleleza, in particular, and in other informal settlements of depossession or displacement, the department intends to undertake the following programs: audit and verify through physical inspection of land occupation and ownership records the details physical identification of various categories of plots and plot owners. B, replanning and upgrading programs, review existing plans and ownership, and realigning development occupation with land records. C, titling and registration, providing formal land ownership documents and residents, recognizing their rights and interests. D, legal frameworks and policies, establishing and enforcing policies and legislations that protect the rights of the residents. Attached are the list of members or the list of occupants according to the Revenue Department. Thank you, Mr. Speaker, sir.
Before you get to your seat, honorable member, is the response sufficient, or would you like to ask a supplementary question or seek clarification on the answers given? Kindly note, I want you to note very well, that you are only permitted one supplementary question pursuant to the standing order number 56, 9B. Honorable member, Joseph Mariga.
Thank you, Mr. Speaker. Mr. Speaker, I expected that the CECM to come with the evidence showing their area which is covered by their SEK, because what I understand is if you are allocated a land, the beacons have to be marked, and in that, the SEK, they know their land very well because it is marked, they have the beacons. And the public land which is now there, I think they have the beacons. If you are given a number, it means that that number you are given,
Honorable member, is the question or are the answers?
It's because I am not satisfied with the answer, so I just want to explain myself so that now she replied. Because if you are given a number, Mr. Speaker, it means that there is a beacon in that plot. So I expected Waziri to come with the evidence showing the area covered with the SK and the area covered under the public land. So and then I don't think if the public participation was done when the project was being carried on. So
Honorable member Kidogo, because this you should come up with a supplementary question like what you have come now. Just organize yourself, you give just a question.
Mr. Speaker,
not explaining.
Mr. Speaker, I am not explaining. I just want Madam CEC to understand the exact thing with what I wanted. Because when she was here last time, she was supposed to come today with the evidence showing what area is covered by SEK. And if the area is covered by SEK, if she had the evidence here, I could not even ask all these questions. Now you understand my point. So I am not satisfied with this answer, Mr. Speaker, because the SK were given land long time ago. That means that land was measured and the beacons were there. So I expected Waziri to come with the evidence showing the area covered with the SK land. That is my point. So I'm not satisfied with the answer because even the public participation was not done. If the public participation was done, it means the SK today could not even complain because they could have agreed with the project to go through. So I am not satisfied with that answer, Mr. Speaker. Then when you go to Peleleza, Mr. Speaker, I am also not really satisfied as the area member of Mwatate Ward, because as it seems, as we speak now, it means that it means that the people who are in Peleleza, they are there, but anything can happen to them. We have seen here some of the people are paying rates in Peleleza. Maybe the CECM should tell the House, did she do the public participation to Peleleza so that to verify the hundreds of people, the thousands of people staying, were born in Peleleza for those many years are still inside the education which will take place. Because as we speak, Mr. Speaker, we have seen so many demolitions which have been taking place within Taita Taveta County, and our people are suffering because the department is not taking these measures seriously. So I expect Madam CECM and the department to tell this house if the people who are living in Peleleza as we speak now, the people who have been there for over 30 years, who are there in Peleleza, and according to these answers which Madam CCM she has given, that there are some people who are paying rates, and we are not sure if the people living in Peleleza right now are the same paying the rates, or these are some of the people paying rates but they don't live in Peleleza. So Mr. Speaker, maybe they should take measures seriously so that my people who are in Peleleza, they won't live in fear. Thank you, Mr. Speaker.
Before you respond, maybe can I also get from any member who may need some clarification of it on the same issue that has been raised by Honorable Member Mwatate. Any other member? So that at least the Waziri can respond to all the concern. Yes, Honorable Mabish Kurubai.
Thank you, Mr. Speaker. Mr. Speaker, it's not about the clarification, but it's about what something small on the SK and the hub plot. As Waziri has explained, I'd like to inform the honorable member that the area is in Chavia and it is under adjudication now. The process is ongoing. It does not be finalized. And it's good that we get to understand that it started, the section that is being talked about, the Chavia Marisecho scheme, started way back in 1972. But up to date, it has not been concluded because started with consolidation, then it turns to adjudication, to state education, something like that. So it has never been finalized, but the process is at its last stages. So I'm sure the moment it's concluded, then the boundaries of the SK and also the that of the government will be well known. But this is the matter that should be taken with a lot of care, because the SK is claiming that where the hub has been constructed is a plot that belongs to the church. So it must be followed with a lot of the seriousness it deserves. So if it belongs to the church, then it needs to be reverted back to the church. Thank you, Mr. Speaker.
Oh, Honorable Member, do you want to bring another issue about the boundary? Oh, so it's a clarification. Honorable Waziri, can you move on and respond to the, and also harmonize before I give direction on that matter?
Okay, thank you, Mr. Speaker. The number was given while demarcation on the ICT hub and the SEK. But as I had stated earlier, the process of adjudication is still ongoing. So getting maps, I'll be giving the wrong information if it is not a complete map, because there are these cases of this belongs to who, this. So the final map has to come from the adjudication office. After they are through with the process, it's when I'll be giving the right information, unless the one they can give is just the process, but the final maps which are signed, this belongs to this or this number belongs to this, it's not final. So Mr. Speaker, sir, it will be difficult for me to get a map which is incomplete. And there were no beacons that were put on that time. So because the process is incomplete until now. So until the process is complete, it's when the beacon will be established. And also, to add on that, I've taken note of the issue of the dispute between the church and the ICT hub. So as the process it is ongoing, it will be prudent for me to intervene on the issues that are raising on the land so that I can be at par with them, so the final map can feature the way it is supposed to be. That is my take. And also I agree the stakeholder engagement was not properly done, including from my department. There was no stakeholder engagement was done. So we ought to start again and do that process and do it properly, so that to avoid further conflicts wherever they arise. In Peleleza, there is disparity between county council records and that of commissioner of lands. The records are differing. However, noting that the allotment letters have guidelines or regulations which the department will be looking at during verification exercises. So if they were provided with the allotment letters, they have expiry. So we will see the regulations when they were allocated, what were the conditions, and we'll work on the same. But as the department, we promise nobody will be displaced. Thank you, Mr. Speaker, sir.
Now, Waziri, I think this, I think it's good that now, because it's the role of this house to give oversight, part of what you are doing. And we have noted that maybe the public participation has not done. That's why the honorable member is concerned. Can you see the engagement on the public participation and also the stakeholders, him being one of them? And also see that those old records and other things are sorted out. Because we cannot dwell on one thing. Let's put records straight. And I think I will only direct the committee lands so that they can now follow up the matter and see that that matter is sorted out and the information is brought into this house within 14 days. So those people can be settled and be assured of their stay. And they are Kenyans, they are paying tax. So these are directives I'm giving, and it should be noted that we cannot delay Kenyans when they demand their services. So you as a CM who is paid, and the Waziri who is paid by the tax of the Kenyans, you need to ensure that these people live in peace. And I'm happy that the honorable member will also follow up that matter. So we are expecting a very conclusive report after 14 days, that whether these people are involved and everything is moving in the right direction. And not only the honorable member in Mwatate, you can also involve other members in that particular sub-county so that you can have a conclusive matter on that particular side of you. Thank you very much. I so direct. Let us go to the next question. Question number 4. Honorable members, I now invite Honorable Joseph Mabishi. You know the names are contradicting, Joseph and Joseph. And this time is Joseph Mabishi, Honorable member from Chavia, to ask the questions on leasehold status and renewal process of Masui Ranch, plot number 12923/2, Taita, title number CR 8679. Welcome, Honorable Member.
Thank you, Mr. Speaker, sir. Speaker, sir, I rise to ask the question, the leasehold status and renewal process of Masui Ranch, plot number 12923/2, title number CR 80679. The first question: was the lease awarded or renewed through a transparent and consultative process involving the relevant county and national government stakeholders? Number 2, to which local community does the land belong? Was it engaged or consulted during the issuance or renewal of this lease? If so, kindly provide the evidence of such public participation. Number 3, who are the beneficial owners or directors of Masui Estate Limited, and what is their current relationship with the local community and the county government? Number 4, has the community benefited in any way through corporate social responsibility projects initiated by the management of this strategic parcel of land? Number 5, which is the last, who receives the annual lease rent of 123,600 Kenya shillings? And how is this revenue accounted for and utilized, particularly in benefit to the residents of Taita Taveta? Thank you, Mr. Speaker.
Honorable members, I now wish to invite the County Executive Committee member to respond to the question raised by Honorable Joseph Mabish.
Thank you, Mr. Speaker, sir. Leasehold status and renewal process of Mwasui Ranch, plot number 12923/2 Taita Taveta, title number CR 80679. Mwasui Ranch forms a part of few individually owned ranches in the county. The land that lies in the southern part of Mwatate within Chabia ward occupies an approximate acreage of 2,025 hectares. The parcel is owned by the late Jackson Shako and the family. The land was first registered on 1st February 1975 as per the official land search. The Land Act 2012 is the primary legislation governing lease renewal and extension in Kenya. It provides the overarching framework for the land administration and management in the county. Additionally, the Land Extension and Renewal of Leases Rules 2017 provide detailed procedures and timelines for renewal and extension processes. The law provides the framework for the lease extension and renewal procedures, requirements, and considerations. Number one, lease renewal. The lease renewal involves creating a new lease agreement and the same property for the same property after the expiration of the original lease. It essentially starts a new lease term with potential new terms and conditions through terms of the new lease although terms of the new lease may closely resemble the old lease. It is legally considered a separate and independent agreement. Key features of lease renewal. Renewals occur either before or after the original lease has expired. Requires negotiating new lease and conditions and executing the new lease agreement. The commencement date of the new lease is typically after the expiry of the previous one. Number two, extension of lease. The lease extension refers to prolonging the duration of the existing lease without creating new lease agreement. The original lease terms and conditions generally remains unchanged. The extension is done during substantive of original lease before it expires. Key features of lease extension. Number one, original lease remains in force. The parties agree to extend the duration of the existing lease without substantive changes to other terms. No need for a fresh agreement, but an addendum of memorandum is often executed. Key difference: renewal of lease creates a new contractual relationship, while extension maintains the existing lease relationship but prolongs its term. Based on this specific concern raised, we wish to report that 1. Was the lease awarded or renewed through a transparent consultative process involving the relevant county and national government stakeholders? The process of renewal of lease, of renewal or extension follows a specific guidelines which requires 1. To fill a specific form, LA 22 or 23, as per the National Lands Commission, who upon receipt the application. The NLC within 7 days forwards it to the Cabinet Secretary for, into bracket, for leases granted by the national government, or the county executive committee member responsible for the lands for leases granted by the county government. The application is reviewed within 90 days of the receipt. It can be approved for specified term with such terms and conditions as may be specified or declined with reasons provided. Based on the nature of transaction of the lease was surrendered for road extension and extension in 2022, while the lease expired on 2020, as per the registration details. Hence, it is not clear how the extension process was obtained, as there are no records of engagement within the office of the county executive member for lands. Number 2, which local community does it belong? What it engaged? Was it engaged or consulted during the insurance or renewal of this lease? If so, provide the evidence of the public participation. The land that is Masui Ranch, being a part of public land that the government, national or county, owns, was leased for a period of 45 years for agriculture and livestock development. Therefore, the land is a public land. It belongs to the state, and in that case, the allocation process is done by the National Lands Commission in consultation with relevant government. The extension process was done, but no proof of stakeholder engagement as per the requirement of Land Lease Renewal and Extension Rules 2017. Question 3. Has the community benefited in any way through corporate responsibility project initiated by the management of this strategic parcel of land? The department has never documented a CSR and therefore has no tangible evidence of any project that the community has directly benefited from the ranch. However, the ranch pays rates to the county, which contribute to our own source revenue that utilizes various projects and service provision to the people, to the residents of the county. Number 4, who receives the annual rent of 123,600 shillings, and how is this revenue accounted for and utilized, particularly in the benefits to the residents of Taita Taveta? An annual rent is payable to the national government as the leaser of the land, while the county only collects land rates. The revenue is accounted for the part of government tax which it collects on the land, and it is utilized for various activities. Thank you, Mr. Speaker.
Honorable member, is the response sufficient? Will you like also to ask supplementary question or seek clarification on the answers given? And kindly note that you only permitted to ask a question, to supplementary question Proceed to the standing order number 56 or 9B. Honorable Obish.
Thank you, Mr. Speaker. Mr. Speaker, all the questions I asked sought to establish whether the due process of the law was followed or not. So I'll have one supplementary question to Waziri. Waziri, as per your knowledge on matters related to land, was the due process in the renewal of the lease followed or not?
Okay, any other member? Maybe before Waziri stands to respond to the concern. Supplementary of the member. Yes, Honorable Amos Makar.
As he responds to that question, I also wanted to get the clarity if the CCM is aware that a resolution was the passed in this house regarding the lease renewals and extensions, Mr. Speaker, because that's a matter that touches so much in this county. There are so many public lands under lease. And I felt like when she talked of the parties, I also want her maybe to clarify which are these parties that are involved in this process. Very important for us to note that. And then it's good for her also to tell exactly who are those people concerned, especially in the matters of the National Land Commission in this county. Thank you.
Yes, Honorable Waziri.
Okay, thank you, Mr. Speaker, sir. It is well put that the due process wasn't followed according to the regulations that are provided by the Land Act 2012 and the rules that were provided on regarding extension and renewals of the leases, that is rules 2017. So in this case, the due process was not followed because there were no public participation done, or all stakeholder engagement was not done. As per our files in the office, the CCM did not was not involved because there's no any letter that is showing or any document that is showing the CCM took part in this renewal of lease. Thank you, Mr. Speaker.
What of Amos Makalo concern?
Okay, the process of renewal or extension of lease, it the parties who are involved are the county executive member, the physical planners, the surveyors, the land administrators, also the county assembly for approvals in terms of county government. And then in the national government, there is lands, that is National Lands Commission, and also national surveyors, that's and the land admin and the registrars. So they are supposed to be part of this team that is supposed to to follow or to do the process of land renewal and extensions.
Aware that we passed a resolution in this house that no any other lease that should be renewed unless it goes all through the process.
I'm aware, Mr. Speaker, sir.
The directives you have committed this house that the due process will not be followed. And if they are not followed, then now you should advise through the committee on what now whether if the process will not followed, you should now advise the committee on the way forward. And also that one can also you have to, before I end, then do you have anything to add? Maybe before.
Yes, Chair. You know, saying the process was not followed does not conclude the matter, because the CCM knows very well the process was not followed. It is quite prudent, and it will be very informative if the CCM can tell us after she realized the process was not followed, then what steps as the CCM learned did she take? Because this is not a new matter. What if the questions were not put forth in this honorable house? Are there any attempts she might have done, maybe, to resolve that matter, or advise the National Land Commission that a breach was done. Thank you.
That is where I was going to. Can you please respond to that before I make the conclusion?
Okay, thank you, Mr. Speaker, sir. As the process was not followed, because we came to realize after we got the renewal of title in our office. So from that, the file didn't have any other correspondent documents to show that there is any process that was followed from our end as the county government. So mine, because the issue was already here, I was to complete with this house first, then the assembly, then I really urge you from the part of assembly to do a resolution on the same, because those resolution will help me to work on. Thank you, Mr. Speaker, sir.
You see, any resolution that is brought to this house, you as an advisor, you should now see whether if the process was not followed as by the way Honorable Member said, it's you now to advise the executive and take action. And then if it comes to this house, then we have no problem. Us is to make sure that the whole procedure is well followed, and we'll have no problem about that. The only thing is not to engage the committee responsible, that is the lands committee. And I think we can as well also give you 14 days so that at least we can get to know how far you have gone about that matter. Thank you. Let us go to the next question. Question number 5. The honorable members, I now invite Honorable Jonas Solomon to ask the question on the status of Mumboria Community Land and Community Land Management Committee. Honorable Jonas Solomon.
Thank you, Mr. Speaker. Mr. Speaker, when we were with the CCM last time here, if you can remember, I advised the CCM to come with a very comprehensive report about Bulia community land. And I also advised the CCM not.
Are you on hazard?
Yes, I am. And also I advised the CCM the matter was very sensitive. She should not allow to carry somebody's cross. Mr. Speaker, I've gone through the answers, the correspondence, the response, and I'm happy about the response. But there are some few questions, Mr. Speaker, which I've doubted.
Honorable member, if you are not if you are contented, because you also not need to hear from the information that you are given you, so that we can go to the next step.
Mr. Speaker, I've gone through the paper,
okay,
and I have all the information.
Okay, good. Just hold your seating.
Mr. Speaker, please don't cut. Mr. Speaker, you're cutting me short. Mr. Speaker, the response which is in this paper, there was a subdivision done in Bulia community land. And with the subdivision, when it is done, there must be a land control board documents. These documents, they are not there. The land control board documents, which have to verify the subdivision was done and the title was issued. Another thing, Mr. Speaker, I wanted to know is I'm sorry, it's getting out of my. It's about Mr. Speaker. Let me remember. The officials, they have stayed in the office for more than the period expected. And the CCM has stated clearly it is illegal. And he wanted to know if there's that illegality, which steps are we supposed, or the Waziri is supposed to take, or the members of the Bulia community land, they are supposed to take. And again, the CCM has said, by today, the Mbulia community land officials, they should have conducted 4 AGMs. And the 4 AGMs have not been conducted, even one, even a single. So if this is the case, how are we supposed to go? Mr. Speaker, that is all what I wanted to ask. Thank you, Mr. Speaker.
Okay, executive member, because the member is contented with the report that you gave, can you please address his concern on the issue that he has raised? Thank you.
Thank you, Mr. Speaker, sir. Regarding the AGMs that the current CLMC was supposed to hold, they were not held, and they have overstayed their tenure in the office. But from the responses, the last AGM that was requested was last week. There was another AGM which was to resolve the issue, but another party went to court and the AGM was stopped, not to happen. And to change the CLMC, there has to be an AGM in place so that it can be changed. So the issue here is about court. The cases are in court, left, right, and center about Mbulia CLMC. So that's where we are locked. We cannot advise or go on with anything because of the court cases as it is. So it's the members to come up with the resolutions on how they can stop these court cases from appearing each and every time they want to hold an AGM. Thank you, Mr. Speaker.
I think, Honorable Member, you have heard from the CCM on the issues about that. Do you have any reaction on that matter so that we can end up with the matter from there?
Mr. Speaker, my concern is AGM has never been held. The officials have been in the office illegally from 2022 to date. What are we supposed to do? Are we supposed to follow up the matter? And again, another question, Mr. Speaker, is the process of changing titles have taken place. Has the Land Control Board been involved? Has the Land Control Board been involved in the process of issuing titles from the Mbulia Community Land or Mbulia Group Ranch to Jam City or those other companies?
Okay, Honorable Waziri, respond to the concern of the member. Remember that about the issue about the court issue, it's good that you advise. You are there now. Can you respond to what they should do? Because that's what you want to hear.
Thank you, Mr. Speaker. As I had reported earlier, the issue of AGM emanates from CLMC. The CLMC is supposed to call for the AGM. And if it doesn't, for the CEC or the department is to advise. And if it doesn't call for the CLMC, the members themselves have the powers to compel the CLMC to call the AGMs. That is my advice. To add on, there are court cases in the court. So from those verdicts, the last AGM they tried to call, that was on 4th this month. The court had barred them from holding the same AGM. because other members went to court. So there is issues between members. My advice is the community, Mbulia communities members should come together and agree amicably not to go to court, because this issue of going to court each and every time brings stagnation, and they will be giving this CLMC in office to continue staying in office, because they'll be replaced only by the AGM. So they should come to terms with, they have to stop going to court, sit down and resolve their issues within, so that they can have an AGM and choose the new office which they want. That is my advice to the Mbulia community.
What of the land commission that he has talked about? Land education that's on process?
Okay, the land adjudication which is in process, I promise I'll facilitate the documents from the land control boards so that you can review what they will give me. I don't want to say much because I don't have documents in hand. I might be lying. So give me time. I go and get documents so that I can furnish this house on time.
I think it's good that honorable member, you also involve the stakeholders, him being one of them, so that most of the issues raised in this house may not come here, because he's raising the issues when he's not getting the information, the right information. So that matter rests at that point, and within also 14 days, make sure that also that one is clarified. Thank you. Let us go again to the next question, the question number 6. And also invite Honorable Peter Shambi to ask the question on the ownership and status of Bachuma Multiplication Center land. Welcome, Honorable Shambi.
Thank you, Mr. Speaker, sir, for this opportunity. Mr. Speaker, I rise to ask a question on the ownership status of Bachuma Multiplication Center land. And here are the questions. Number 1, who is the legally recognized owner of the land currently occupied by the Bachuma Multiplication Center? Number 2, is the land registered, and if so, and what title deed number, size in hectares, acres, and name of the title holder? Number 3, what is the nature and basis of the dispute between the two governments regarding the center? Number 4, have there been any official correspondences, court cases, or mediation attempts initiated between the county government and the Ministry of Agriculture over the ownership and control of the center? Number 5, what positions does the county government of Taita Taveta, particularly the Department of Agriculture and Livestock and Development and Department of Lands, Physical Planning and Urban Development hold in regards to the ownership and intended use of the land? Number 6, have there been any development projects or donor-funded programs linked to the center that have stalled due to the ownership wrangles? Number 7, what steps is the county government taking to secure legal ownership or user rights over the land for the benefit of Taita Taveta County residents? Thank you, Mr. Speaker, sir.
Honorable members, let me now invite the County Executive Committee member to respond to the issues raised by Honorable Member Peter Shambi.
Thank you, Mr. Speaker. Question 1. Who is legally recognized owner of the land currently occupied by Bachuma Multiplication Center? Historically, the land was listed as government land, that is GL, currently known as public land. The use by the veterinary department as livestock quarantine station, also known as Bachuma Livestock Multiplication Center and Demonstration Ranch, LMD. The county government of Taita Taveta has for years used and managed the large parts of it, thus laying claims it to as the county asset. While the Environment and Land Court accepted the county's position that national agencies acted inconsistently with the Constitution when they floated a 30-year lease, it did not order an constitution. Registration of title of the county because the petitioner had not provided all procedural steps for an outright transfer. Number 2, is the registered land, is the land registered, and if so, under what title deed number, size in hectares, and the name of the title holder. Bachuma LMD land is not registered and therefore has no title number. Records and references in the court judgment indicate the parcel as being public/government land previously under the Veterinary Department National Public Government land, previously under the Veterinary Department National Livestock Programs, preliminary, and the land measures approximately 15,000 acres. The judgment does not state whether a title should be issued to the county. In short, it remains in the contest public state category rather than showing a clean registered transfer into the county's name. What is the nature basis of dispute between the two governments regarding the center? The core dispute is whether the Bachuma LMD, Bachuma Livestock Quarantine Station, is the national function asset to be managed by national agencies, or county function asset vested in the county after devolution and stable and unstable for county livestock activities. The National Ministry State Department of Livestock published a tender July 2024 to lease the approximately 15,000 acre facility for 30 years to a private operator. The county argues the land has been used for county livestock breeding multiplication, was developed with county resources, financial as well as human, and that the national tender bypassed consultation and infringed devolved function. The county challenged the tender as unconstitutional and in breach of public participation / devolution safeguards. Number 4, have there been any official correspondences, court cases, or mediation attempts initiated between the county government and the Ministry of Agriculture over the ownership and control of the center? Yes, there have been formal correspondence between the county government and national government, IGRTC, and the court proceedings. Key items: the county wrote to the State Department protesting in unilateral decision to advertise and tender its land. Parties took the dispute to Intergovernmental Relations Technical Committee, IGRTC, as required by the process, did not resolve the matter. The county filed a constitutional petition in the Environment and Environmental Court, petition number E008/2024. The court issued orders of conservatory, inhibitory orders, and delivered a full judgment on 23rd October 2025 that squashed and nullified the national tender and restrained the ministry from implementing it. Number 5, which position does the county government of Taita Taveta, particularly the Department of Agriculture and Livestock Department and Department of Lands, Physical Planning, Urban Development, hold regarding ownership and intended use of land? The county government of Taita Taveta and the Department of Lands, Physical Planning and Urban Development, in particular, hold the following position: that Bachuma is effectively a county strategic asset as used as a multiplication stroke breeding center. Under Article 63(2), public land vests in counties, and the 4th schedule aligns agriculture livestock functions to counties, and therefore the national government purported advertisement for expression of interest in the land for investment without consultation with the county government authority was unlawful. That is why the county sought orders to stop the process. The court agreed the tender process was unconstitutional, but stopped short of ordering immediate transfer registration in the interests of the county government. Number 6, have there been any development projects or donor programs linked to the center that have stalled due to the ownership wrangles? No. However, it is in record that National Government Leasing Commercialization Plan 30-year lease a land commercialization initiative was halted by court orders, and controversy itself held planned private investment initiative. Other development activities tied to the contested tender were therefore put on hold pending resolution. The court decision and the previously issued conservatory orders effect stall planned development projects. Number 7, what steps is the county government taking to secure legal ownership or user rights over the land for the benefit of Taita Taveta residents? A, administrative action. The county wrote formally to the State Department protesting the unilateral decision to float the lease on county government land. Intergovernmental process. The county government engaged IGRTC committee for dispute resolution. 3, judicial relief. The county filed the constitutional petition in the Environment and Land Court Petition 008 of 2024. Sought injunctive and declaratory relief and challenged the tender. The court squashed the tender and issued an inhibition order, that is judgment 23rd October 2025. Public legal argumentation. The county framed its case around articles of the Constitution, devolution, public participation, and argued that the national agencies must follow constitutional transfer consultation steps before alienating land that county uses. B, planned actions way forward. The court has disowned the national government lease of Bachuma. That is, the tender was squashed and implementation inhibited. That is a strong legal win for the county's position on process of devolution. However, the court did not pronounce itself in the question of transfer registration of the land. It's only stopped the leasing stroke commercialization initiative upon finding the national government agencies conduct and constitution, but left some procedural issues unresolved. The matter of land registration still requires administrative steps for further court directions if parties pursue them. However, to secure legal ownership of the land, the county will immediately initiate proceed with the registration process, namely preparation of necessary plans, PDP advisory, and surveying of the land for the purposes of registration in collaboration with the National Lands Commission, LLC, and the national government through the Ministry of Lands. Thank you, Mr. Speaker, sir.
Honorable member is allowed to seek clarification. Once are given, pursuant to the standing order number 56(9). So, Honorable Shambi, you can proceed.
Thank you very much, Mr. Speaker, sir. Mr. Speaker, first and foremost, I want to take this opportunity to thank the CCM in charge of this department for the elaborate answer that she has given. And I'm happy that this matter was in court and the court ruled to our favor. However, Mr. Speaker, I only have 3 questions. I would like to supplementary question to hear from her. And the first one is that Article 62(3) of the Constitution expressly gives the authority of the county governments to own public land. And here we are looking at a matter whereby this particular piece of land that was earmarked for livestock activities was supposedly belonging to the county government. But now it is coming out clear that the county still does not own it. So maybe I just want to understand why this has happened. Why is it that we do not have, as a county government, we have not moved in to be able to register and own that piece of land to be able to avoid unnecessary litigation like what we have just seen? And the second question I would like to ask is about when the county government went to court to defend the leasing of this particular piece of land for the 30 years that has been said here, the court ordered that that particular lease discussion is quashed or suspended, but it did not expressly order that that land is expressly registered and automatically get owned by the county government. Now the question is, why was there not that prayer? Because the court cannot respond to something that has not been prayed by us who are supposed to be the petitioners. Why was there not that prayer, or what are the circumstances that led to this particular judgment or the ruling to become of this nature? And lastly, Mr. Speaker, sir, is based on what we are seeing at the Livestock Multiplication Center and what is transpiring, it is sending a very serious signal that other pieces of land belonging to the county government are also under threat. And they're under threat because they might have not been registered and even titled in favor of the county government. So there emerges 2 questions. The question is, what are some of the safeguards that the county government has put in place to ensure that this land is secure? And secondly, what other action is your department, Madam Waziri, taking to ensure that these things do not happen now and even in future? Thank you, Mr. Speaker, sir.
County Executive Member, can you please respond to those concerns?
Thank you, Mr. Speaker, sir. In question 1 regarding the land why it was not registered before, after the devolution, there was handover of the register or asset register. So after the handing over, the department was supposed to do the audit of all public land and unregistered, of which that one is already done. The register, we already have the register of all public land. And from the report that I gathered on all the public land in Taita Taveta, the most of the public land is unregistered. And we've set aside the recommendation on the registration process because it takes time, because a lot of land in Taita Taveta is not registered. So it takes time. So we have the plan as the department. We also have budget constraints from our end, because in terms of registration, there is surveying, there is planning, there is mapping. All that process needs funding. So we are constrained in terms of funding, but in this budget, we've tried to see how many we can start, even if we start in phases, because we cannot do all of them on the same. In terms of the judgment, Mr. Speaker, sir, that one will be difficult for me to answer, because in legal matters, I'm not the expert. So maybe I don't know if the legal department floated the plea so that the judge can determine the land belongs to the county or not. Maybe it was over, it wasn't, maybe he presented, maybe he didn't present. So I'm not in a position to answer that, Mr. Speaker, sir. Thank you very much.
Honorable Member Shambi.
Thank you very much, Mr. Speaker, sir. Mr. Speaker, I think the response that she has given is quite sufficient, but through through a resolution that needs to be made in this House, I feel like the issue regarding what she has just mentioned on audit and identification and registration of public land, it is, for me, I feel is an urgent issue, Mr. Speaker, sir, because as we speak today, we have about 7 pending evictions in this county, Mr. Speaker. And these evictions, some of them border into public land. And therefore, I feel like even before the CCM leaves this House, there should be a direction on how we need to specifically address this issue of registration of public land. Because this is a matter, for me, number one, is urgent. Number two, it cannot wait for tomorrow. It is an issue that we need to resolve it now, whether we are going to do it as a House or through the relevant committee, but we need to urgently convene a meeting with the department and any other person who is responsible to be able to address this particular matter. Number two, Mr. Speaker, we need to have the person in charge of the legal, what is his title? The legal director, legal affairs director or something like that. The person who is in charge of this particular court matter, Mr. Speaker, to be able to explain and give a comprehensive report of exactly what happened. Because the resources were utilized, there was an opportunity for them to be able to pray for this, for an express judgment of this land to be registered into the county government. This has not been done. So if we have, for example, if we need to go back to courts to be able to get that order, we'll have to spend more money, Mr. Speaker. And therefore, I feel there was something that was not right, and something needs to be fixed, specifically on this particular issue. So I would want to beg your direction in terms of how we approach the issue, both on the legal side and even on the administrative side, and also to try and see if the constraint is the budget, what is it that this house is able to do to able to facilitate that process and support the department to be able to execute these particular responsibilities. Thank you very much, Mr. Speaker, sir.
Now I think honorable member is good that you are contented, but now the issue is already pending. When an issue is hanging, then it also gives a lot of question on that. Because when you look at the judgment, as you have said, I think it's good now because we have the legal part of it in the county. You as the CCM, it's good now you also find the legal part of it and see where we can come in and also advise. And this one also you can as well liaise with the large committee and also for the member to be very convinced on that particular matter. Make sure that that matter puts it to rest. We also need that report, that advice on and also the cost, so that we can see how we can come in, so that that matter can also be put to rest and our members. And if it's about ownership, if it's account ownership, then that land can also be put to use. I think I saw direct, and I think within 14 days can also be done. Thank you. Let's go to the next question, please. Question number 7. Honorable member, I now invite Amos Mwakalo, Honorable Amos Mwakalo, to ask the question on the status of the Community Development Agreement Committee. Welcome, Honorable Amos.
Thank you, Mr. Speaker. I've gone through the responses here, Mr. Speaker, and with your guidance, I feel because of the interest of time and looking at the fatigue of the honorable members, I'm not looking forward to ask all the questions because some of the answers have been given to me. I think I'm much better, but allow me to just clarifications she might share on an answer that she has given. One of the issues is about the court ruling that was done. According to the report here, it's clearly that there was a court case, but the ruling was done on the Rockland Limited, Kenya. But that the ruling was somehow favorable, and I wanted her to explain now that a ruling was done. What plans have they put in place? And on top of the plans that you have captured here, all these minings which you don't have at the CDSC committees, I want to know efforts, because clearly they have shown us they have plans to carry out routine inspections. But this is not a new matter. Mining is happening. Mining has been happening. When the CCM and the team says that they are planning, then it tells us we don't know when. So I want commitment on this matter because it has not happened. I want her to give commitment on when, because mining is currently happening, and some of these activities are happening when all this, including Rockland Limited, have not complied to have a CDSC active. So maybe she can clarify when, among others. Then on employment, she also responded to Mr. Speaker. But it goes without saying that when I ask a question as a member from Kasigao, I expect among the companies mentioned on response, she will also touch Kasigao. So I don't know whether she did not get details completely on the companies that I know that come from Kasigao. In terms of their employment, was it that it was difficult for them to obtain the data, or they did not want to burn the midnight oil? Because they must have known this statement has come from a member from Kasigao, and the answers here, I'll definitely take them back to the community that I represent. So I don't know why they decided to dig into other areas, and for even not forgetting to dig into answers of the question seeker. That matter, it was a matter that I have interest on, especially to respond to some questions that members of my community have been asking. So I still have not answers for that. Maybe she can clarify and in direction, Mr. Speaker. Maybe I can be able to maybe convince. But largely, and the other answers they have been given here, Mr. Speaker, I am largely contented with them. Though they still have some little bit of work to do, so that to make sure that as much as mining is not fully devolved, but when I followed through the Senate meeting, it is very clear that there's so much as a county we can choose to do if we want to control mining. And one of the areas is making sure there's proper compliance. If they can fully push on compliance, Mr. Speaker, I believe we'll achieve something. So I feel they have relaxed on following through compliance because this act has been there, the regulations have been there, the companies are mining, and the people are still sitting in the offices. So maybe they can clarify on those just two issues, Mr. Speaker, and I'll be good to go. Thank you.
Okay, honorable members, let me invite the CCSM so that at least he can also respond goes to the member on the issue that of concern. Welcome, County Executive Committee.
Thank you, Mr. Speaker, sir. On formation of this community CDAX committees, we've started the move by compelling the regional mining officer is the one who is supposed to call the meeting. Then you have seen in the introduction, the formation of the CDAX is the representative of the governor, the national government representative, and all that from the list. Those are the representative. So as the department and as the county government, ours is to write or to talk to the regional mining officer. That is, now they are called mining officers, county mining officers, so that we can get all the data, because they are the ones who have the data of the income of the companies. We get the data from the income they get from the minerals, so we get the data from them. So I commit to this house. Within 14 days, I'll write a letter to the regional mining officer pointing all the companies that doesn't have the CDAX to make sure that they are in place, because we do them in collaboration with them. That is my commitment to the house. And in the issue of Rockland, the court case that was the judgment was on 12 May 2023. The company argues that the imposed royalty constitutes an unfair tax burden, and they were introduced without sufficient public participation. So on this issue, we also write the letter to the RMO and advise him to write to all companies, including this Rockland. So if they don't respond, it's when we'll know the next step to take. Thank you, Mr. Speaker, sir.
An issue about employment, also the efforts, because now the honorable member also wants to see your effort. What are the efforts that your department is putting towards ensuring that there is compliance, and also the issue about employment?
Mr. Speaker, sir, regarding that, I'll also get the information from the companies on their employment details of the people who are working within their companies. Then from that, I'll share with the House and see way forward if they meet the criteria which is needed of the locals. Thank you, Mr. Speaker, sir.
The effort now on there is initiative that is the member, honorable member, want you to assure into this house that what are the efforts you are making to make sure that also the compliance. And I think about the compliance we have talked about, maybe the companies were not they were not involved in maybe the rates decision and other things. So what are you going to do about that, so that at least you ensure compliance on the payments of the rates?
Thank you, Mr. Speaker, sir. As I've stated, I'll do a letter to the regional mining to get all the companies which are and their status and their incomes, so that I can also officially write to them and ask for the same records. And also, in terms of public participation, I'll do several public participation to the community to sensitize them so that they can know their rights to get local jobs. Thank you, Mr. Speaker, sir.
Within also 14 days, as you also comply with the information that honorable members not gotten, also need also to see that efforts right from the records. Let us move to the next question. You can nod your seat. The question number 8. The question number 8, I wish to invite honorable member Anissa Mwagi. I don't know who is representing, so that you can ask a question on the status of Juakali Invoy near Kenya Power offices. Welcome, Honorable Shambi, on behalf of the chair.
Thank you, Mr. Speaker, sir. Mr. Speaker, I stand in on behalf of Chair Honorable Anissa Mwagi to ask a question on the status of Juakali plots in Voi near Kenya Power offices. Question number 1, what is the current status of the Juakali plot following the department and the committee's resolution for beaconing during the field visit conducted? Number 2, has the department implemented the beaconing exercise as earlier agreed? And if so, when was it completed? Number 3, if the beaconing has not been carried out, what challenges or constraints have hindered its implementation? Number 4, what measures are in place to ensure the security and preservation of the Juakali plot as a public utility? Number 5, are there any reports of encroachment, illegal allocations, or disputes relating to the Juakali plot, and how has the department addressed them? Thank you, Mr. Speaker.
Honorable members, let me now quickly invite the County Executive Committee member to respond.
Status, Mr. Speaker, sir. Status of Juakali plot in Voi near Kenya Power offices. Introduction. The land identified as Juakali plot near Voi Kenya Power substation was part of reserved land for industrial usage as per the approved plan 1970 and subsequent review of 1991, which also noted the same use. The allocating used PDP is attached. Based on specific concern raised, I wish to report that what is the current status of Juakali plot following the department and committee resolution for beaconing during the field visit conducted? The current status of the plot is that it is still under industrial use after allocation was done via PDP, which was prepared on 2001 to give rise to the light industrial maize milling plant and a medium class hotel, with both parties having an allotment letter of Commissioner of Lands, give them the legal ownership status. Hence, beaconing could not take place due to the private nature of ownership. Has the department implemented the beaconing exercise as earlier, and if so, when was it completed? The department could not undertake the beaconing exercise because the due diligence conducted identified the land to be under private tenure status, therefore could not survey any private land without the owner's consent. Number 3, if the beaconing was not carried out, what was the challenge constraints have hindered its implementation? The main challenge is pure encroachment. If if you were to survey and beacon someone's land without prior consent or owner's consent, the land was allocated to parties mentioned above and they have allotment letters. Although they have not finalized registration processes, they claim ownership. What measures are in place to ensure security and preservation of Juakali plot as a public utility? The area no longer public and land for the government transferred rights through lease agreement and current owners applied use for maize milling and hotel. What measures are in place to ensure the security, preservation of Juakali plots as a public utility? The security and preservation are controlling land use is not to change as per allocation procedure. Secondly, by acquiring land rates, we protect the land from being converted into other uses. Thank you, Mr. Speaker, sir. To add on that, the issue of replanning and alteration of PDP is happening a lot. And this issue is the one which is bringing new landlords or new leases or new allotment letters. So I'll advise this house to do a resolution or to have a resolution that all titles, all allotments that have been done from the year the PDP was prepared be verified again, because the PDP is being altered, allotments are being issued left, right, and center, which is bringing these issues on the table, and people are locating themselves land illegally. Thank you, Mr. Speaker, sir.
Now let us have a member. You have any supplementary question or any concern?
Thank you very much, Mr. Speaker, sir. Mr. Speaker, I might not have supplementary question, but I shared this response with the chair, Lands, and she gave me feedback and she asked me to request that you give a direction for us to be able to get the following documents that would help us in verification and also corroborating the response that we have received from the Waziri. And number one is the minutes of the Municipality Council of Voi that approved the change of user. Number two is the Gazette notice advertising the PDP. Number three, the approved part development plan. Number four, the District Planning Committee minutes proving the part development plan. Number five, the letter forwarding the said PDP to the Director of Physical Planning for approval. Number six, the approval of the PDP by the Commissioner of Lands. Number seven, application by the beneficiaries to the District Plot Allocation Committee. Number eight, minutes of the District Plot Allocation Committee approving the applications by the beneficiaries. Number nine, copies of the letters of allotment, including evidence of payment within 60 days. This information is on soft copy, Mr. Speaker, sir, and therefore I'll be in a position to share with the clerk so that she can be able, they can be able to follow up on these particular documents. Thank you, Mr. Speaker.
You have raised a concern, Honorable CECM, And this is a house of rules. Where you want us come, you just give us a report and we can come in through the committee, House Committee, Lands Committee, so that at least we can put things right. We cannot have a section of a government that is operating outside the government. That one cannot happen. So let us have things done rightly, so that at least we can find ourselves moving. So let us go to the next question. Number 9. This one, I will wish to invite Honorable Stephen Zai to ask the question on the ownership status of land parcel along Mombasa Nairobi Highway between Maungu Pipeline Village and Miaseny. Welcome, Honorable Zai.
Thank you, Mr. Speaker, sir, for giving me this opportunity to ask the question, the status of land parcels along the Mombasa Nairobi Highway between Maungu Pipeline Village and Miaseny. Mr. Speaker, sir, I have the response here, but I'm not satisfied with the response. Let me ask the two questions which were provided. What is the current status of revocation of title deeds that were allegedly issued for parcels of land illegally allocated outside the Maungu Buguta settlement scheme perimeter along the Mombasa Nairobi Highway between Maungu Pipeline Village and Miaseny following the resolution you made? 2, do you have detailed documentation and evidence supporting the claim that procedures were not followed? Thank you, Mr. Speaker, sir.
Honorable County Executive Committee member, you can respond to, first of all, you have heard that is not contented with the report. Can you also respond to the concern?
Thank you, Mr. Speaker, sir. As I had stated earlier on the responses, the procedure was illegally done, and this matter, I had reverted it to the legal team so that they can advise the community on way forward going to court, because the only entity that can revoke this title is the court. So the legal team is having these issues. So I like more time so that I can engage with the legal team and see how far they've reached. Thank you, Mr. Speaker, sir.
Are you contented with that?
Mr. Speaker, sir, I'm not contented with that, because even when you see the response, the same response Waziri has been giving us for the past 6 months, it is the same. And what she's saying, it is different with the response. Because if she has advised the community to go to the court, now it's about 6 months. Since we had the meeting with her to that place, up to now, there is nothing is going on, and the committee feels that anytime they can be demolished and they will lose their lands. So, Mr. Speaker, sir, maybe you advise me how to go about it, because I don't see if I will see the light of the day according to the responses I'm receiving every day, and now they are the same. It's like since that day we had the meeting, the Waziri, I can say she has done nothing up to today. Because we have all the relevant departments. We have the Department of Lands, we have her department, we have our legal here at the county assembly, at the county level. So I don't see why they're taking a lot of time, Mr. Speaker, sir. So maybe Waziri, he give us a time frame and her commitment. Thank you, Mr. Speaker, sir.
Honorable CM, you see, Avado, you always talking about we are doing this, we are planning to do this, but your department must be very aggressive. That's why we are very much concerned, because there is a lot of cases that have to do with the land in this county. Unless you pull up that pressure and make sure that things are moving, we'll always coming here and giving us 14 days. So what commitment do you want to give today in this house, so that the honorable member can also go back to the residents and the electorates and tell them that this is what are the measures that he can now give, that now we have been assured and things are going to work. Can you respond?
Okay, thank you, Mr. Speaker, sir. I'll need like 3 weeks so that I can liaise with the legal department and go and meet with the parties, the aggrieved parties, so that we can see how we can help them move to court. Because from the processes, as the county government, we cannot go to court because we are supposed to produce evidence. So you cannot go to court and also produce evidence. So literally, they are the ones who are supposed to go to court. And for us is to give the evidence that this process was not followed because we missing such and such documents, or what and what is not happening, is not documented. So 3 weeks, alliance with the legal department, we sit with the community, then we advise the community, because going to court needs funds, and my department does not have that allocation. So I have to liaise with the Department of Legal so that they can advise accordingly. Thank you, Mr. Speaker.
Now, as you now plan and do what you want to do, ensure that you also involve the stakeholders, the honorable member being one of them, so that you can also you can as well also involve the legal department and the both sides, and also the committee, the land, so that at least we can have this matter and also our people living in peace, so that we may not have problems that are happening in some areas like what you have had in some areas where people are being evicted. So let us have that one done within the 21 days that you have committed this house. Honorable members, let us put that one, because I've directed into rest, and that being the last question, let me take this opportunity. Having concluded the order for the response to the questions, I now direct the sergeant at arms to escort the county executive committee member out of the chambers. Honor, please.
Order number 8, motion and bills.
Honorable members, there being no other business, the House stands adjourned until Wednesday, 5th November 2025 at 9:30 a.m.